Hi guys, Joe Wolverton, Teacher of Liberty, back here with you for another video for this week. I'm trying to do more of these shorter videos, trying to keep them to around 10 to 15 minutes tops. And then on Friday, the Founders Recipe Fridays, doing 5 minutes on these people. And I've got a lot of those ready to go. And wanted to talk to you today about something that never gets talked about, well, rarely. I'll introduce this by saying that many of you may have seen the shirts that my students created that say factious and discontented since 1776. Well, I'll tell you a little bit about that to lead into what today's video is talking about. So, when in 1799, the state government of Virginia passed what are known to history as the Virginia Resolution, which basically was written by James Madison in answer to the Alien and Sedition Acts, which had been passed by Congress and signed by President John Adams, which basically gave to the president his sole authority to decide if a foreign person was an enemy to the United States, and if so, they could arrest them or expel them. And it also gave to the president power to arrest anyone, an American, who he believed was a threat to the safety of the United States based on that person's criticism of the government. Now, Thomas Jefferson's own member of the House of Representatives was arrested, and this blew his mind. So Jefferson and Madison got together. Jefferson wrote the Kentucky resolutions. Madison wrote the companion resolution in Virginia, which was passed by the state of Virginia. Well, then once it passed, there was this small group of people in the Virginia state government who said, there's no way that you people, our colleagues, could vote for this resolution, which basically says that there are limits on federal power. He said, James Matt, he didn't mention him by name, but he said, those people who have supported this resolution, who helped it pass overwhelmingly, you people are being factious and discontented in your efforts to restrain the power of the federal government. So that's why myself and my students, we took it as a badge of honor to be called factious and discontented, because that to us was a sort of backhanded compliment, because it's what was said of James Madison and Thomas Jefferson when they said, the Constitution doesn't place limits. It actually gives very few and defined, Federalist 45, few and defined powers to the federal government, and the state government powers are, Federalist 45, numerous and indefinite. So, when this little minority issued this statement calling Madison and the Virginia state government factious and discontented, Madison jumped right back and said, are you crazy? There's no good argument for saying that the federal government has the power that you are suggesting it should have. The Constitution, the four corners of that document, are the limits of federal power, and it has no power outside of it, and that's clear. So he wrote something that's called in history the Report of 1800, or Madison's Report of 1800, that he wrote in November of 1800 as the head of a committee, and he said, look, here's why we approve this, here's why you're wrong saying the federal government has no limits. Well, just after that, a little while after that, the first Chief Justice of the Virginia State Supreme Court, named Edmund Pendleton, he wrote, which I have a book of his writings right over here, Edmund Pendleton wrote something called The Danger's Not Over, where he said, if you people, my fellow Americans, continue on this path where you let the federal government each year do more and more, each year grab more power and more power away from the states, where each year you allow the federal government to get deeper and deeper in debt, you will find out that the danger is never over. That you will literally, just when you think it's as bad as it could be, it gets worse if you allow that to happen. So I want to share with you today a few quotes. Now, like I say, the logistics today are a little bit different. So I'm in a different room of the library, right? I'm here with my man Kevin and Uncle Algie, who is really my first cousin, but we call him Uncle Algie. So I'm going to read. We got Mjolnir up there. I'm going to go straight Mjolnir on those people who think that there are no limits to the federal government. We got G-Dub, whose birthday we celebrate. Anyway, so let's get into this. So here's a few quotes. First from Madison's Report of 1800, and second from Edmund Pendleton's Danger Not Over. All right, I'm just going to read these quotes, get these out. I want you to listen to this video over and over. Think about these things. This isn't Joey. Remember, the whole deal is I'm never political. The Constitution, every issue, every time. No exceptions, no excuses, no respecter of persons. I'm not pro-Republican Party, I'm not any of that. I'm pro-liberty. All right? Pro-liberty. So, remember, this is James Madison I'm talking about. We're going to talk about Edmund Pendleton, right? These are the principles that our forefathers clung to. And if we don't, we'll find out that really the danger is not over. So here we go. James Madison. It appears to the committee to be a plain principle founded in common sense, illustrated by common practice, and essential to the nature of compacts, which is their word for contract, which was the Constitution, that where resort can be had to no tribunal, court, superior to the authority of the parties themselves are the rightful judges in the last resort, whether the bargain made has been pursued or violated. The Constitution of the United States was formed by the sanction of the states given by each in its sovereign capacity. It adds to the stability and dignity as well as to the authority of the Constitution that it rests on this legitimate and solid foundation. The states, then, being the parties to the constitutional compact, and in their sovereign capacity, it follows of necessity that there can be no tribunal above their authority to decide in the last resort whether the compact made by them be violated. What does that mean? There is one highest authority, and that's whether the Constitution is being violated by the other party, by the federal government. That's the states, not the Supreme Court, nobody. The states. Do you hear that? The states being parties to the constitutional compact in their sovereign capacity, there can be no tribunal above their authority to decide in the last resort whether the compact made by them be violated. Conservatives say that that's not true all the time. All the time they misquote Article 6, the so-called Supremacy Clause. Well, federal law is supreme. That's not what it says, y'all. It says the Constitution and laws made by the United States are the supreme law of the land if it if those laws are made in pursuance of the Constitution. If they're made in violation, the Federalist Papers make it very clear. Any act of the federal government exceeding its constitutional power is void. It doesn't even exist. All right, next quote from Madison's Report of 1800. If the deliberate exercise of dangerous powers, palpably withheld, kept back by the Constitution, could not justify the parties to it in interposing, standing between, nullifying, even so far as to arrest the progress of the evil. What's the evil? The federal government acting beyond its capacity, its constitutional authority, and thereby to preserve the Constitution itself, as well as to provide for the safety of the parties to it, there would be no end to all relief from usurped power, and a direct subversion of the rights specified or recognized under all state constitution, as well as a plain denial of the fundamental principle on which our independence itself was declared. Do you get that? That if you're suggesting that states cannot say, federal government, you don't have this authority, and considering that stopped at the state border, that unconstitutional act of the federal government, that what you're saying is there is our independence, the fundamental principle on which our independence itself was declared, is plainly denied by you. If you're suggesting that once Congress acts, regardless of whether it's in pursuance of its constitutional authority or beyond its constitutional authority, if the president acts beyond his constitutional authority or within it, if the courts act within it or beyond it, if you're saying that, well, once the federal government has decided that's that, you are denying the fundamental principle upon which our independence was declared. You can't get clearer than that, y'all. All right. The Judicial Department, again from Madison's Report, the Judicial Department is in all questions submitted to it by the forms of the Constitution to decide in the last resort. This resort must necessarily be deemed the last in relation to the authorities of the other departments of government. In other words, when a constitutional question comes to the Supreme Court, that's the last word with regard to the three departments of the federal government. Not the last word regarding state laws or even the Constitution itself and the relation of states to it. It simply is the last resort for the authority of the other departments of government. Not, says Madison, not the last resort in relation to the rights of the parties to the constitutional compact from which the judicial, as well as all other departments, hold their delegated trust. We cannot let the Supreme Court decide the limits of federal power. Why? Because the Supreme Court is part of the federal government. Look, if I'm playing baseball and I'm a batter and I'm allowed to decide every pitch is a strike or a ball, guess what? I'm walking every time, and I'm going to steal every base, because whether I'm out or safe, guess what? I'm safe. And when we say the Supreme Court, once it decides, it's done, and that's the last resort, we're saying the federal government is the umpire in its own game. Ridiculous, says James Madison. Ridiculous. On any other hypothesis, he says, the delegation of judicial power would annul the authority delegating. Where does the Supreme Court get any power? The Constitution. Who are the parties? The states. If you say the states are bound by the decision of the authority it created, then they really have no authority. As he says here, you are saying that they have no authority. The states do not even have authority. On any other hypothesis, they would annul the authority. So it's saying, states, you have no authority. That's ridiculous. And the concurrence of this department with the others in usurp power. In other words, when the Supreme Court says, yeah, the president can declare war, it's cool. Yeah, the Congress can give him that power, it's cool. Yeah, Congress can tell everyone that they have to get their permission in order to dig a pond. Yeah, that's cool. Yeah, whenever Congress can give $1 billion to a country in aid. Yeah, that's cool. Whenever the Supreme Court decides that, whenever the Supreme Court says, yeah, you can't have assault weapon. When the Supreme Court says, or when the president says, yeah, it's cool that I declare a piece of plastic to be a machine gun and you can't have it. All of these things, he says, when you do that and the judicial authority, the Supreme Court concurs with these usurped powers, that subverts forever and beyond the possible reach of any rightful remedy the very Constitution which all were instituted to preserve. Do you understand that? Guys, know this like you wrote this. I'm going to put a link in the show notes. The Report of 1800. Very simple. Madison saying, y'all don't understand. Think about it. This is 1800. People already trying to get away with stuff. Madison's like, look, The Supreme Court can't be the judge in its own case. That doesn't make any sense. Plus, it's only to be the judge with regard to the federal government. It can't judge about the states. The states created the dang thing. Try telling your boss what your job description is. You tell him, no, I'm not going to do that. If it's in your job description, you're fired, right? But we don't even do that. If the Supreme Court says it's cool, yeah, go ahead. James Madison, do you hear that? Hear that whirring sound? I know you do. That's Madison and Jefferson spinning in their graves. All right. Next, it will be remembered, this is from the report of 1800, it will be remembered that a frequent recurrence to fundamental principles is solemnly enjoined by most of the state constitutions, enjoined meaning encouraged, told to do something, by most of the state constitutions, and particularly by our own, Virginia's, as a necessary safeguard against the danger of degeneracy to which republics are liable, as well as other governments, though in a less degree than others. And a fair comparison of the political doctrines not unfrequent at the present day with those which characterize the epoch of our revolution and which form the basis of our republican constitutions will best determine whether the declaratory recurrence here made to those principles ought to be viewed as unseasonable and improper, or a vigilant discharge of an important duty. The authority of constitutions over governments and the sovereignty of the people over constitutions are truths which are at all times necessary to be kept in mind, and no times perhaps more necessary than at the present. Madison was saying that in 1800, guys. In 1800, he's saying, you have got to frequently remind yourself of the fundamental principles of the Revolution, of the Declaration, or else our republic is going to degenerate. If you don't think our republic is degenerating, you are not paying attention and you're part of the problem. Our republic is degenerating, maybe has degenerated. But here we come, and so he says you've got to do that. Otherwise, then you've probably gone so far that it can't be restored. All right, here, finally, Danger Not Over, Edmund Pendleton, October 1801, first published in the Richmond Examiner, right? He says, government, so this is Danger Not Over, I'll put the link down. Government is instituted for the good of the community and not to gratify avarice or ambition. Therefore, unnecessary increase of debt, appointment of useless officers at a time when the business of the federal court is greatly diminished, and engaging us in a war abroad for the sake of advancing party projects at home are abuses in government. Unnecessary increase in debt, appointment of useless officers, engaging us in a war abroad for the sake of advancing party projects are abuses. That whirring sound, that's a problem with being so close to outside. I don't know what's going on. I don't care, but y'all can hear me, I'm sure. So let's just keep on keeping on. So again, Edmund Pendleton, the chief good derivable from government is civil liberty. And if government is so constructed as to enable its administration to assail or attack that liberty with the several weapons heretofore most fatal to it, then the structure is defective. If your government that you created to protect your liberty is now attacking your liberty, you have a problem. Of this sort of defective government, standing armies, standing armies, navies, severe penal laws. Did you see the other day President Trump saying he had the authority to make animal cruelty a federal offense? Where? And the first line of the order that he issued said, per my authority in the Constitution. What? We gave presidents power to make laws like that, impose on the states? So you talk about here, severe penal laws, war, and a multitude of civil officers. Do you know there are more bureaucrats, government officers in the state of Nevada, or Nevada as y'all say out here, then in the entire Roman Empire at its height, at its largest, one state, Nevada, has more government officers, more government bureaucrats than the whole of the Roman Empire. If our government can, with ease and impunity, array these forces against social liberty, the Constitution is defective. Meaning what? We got to do like Madison said, get back to fundamental principles. Because if we don't, it may be too late. All right. Peace is undoubtedly the state which proposes to society the best chance for continuance of freedom and happiness, and the situation of America is such as to expose her to fewer occasions for war than any other nation. Who's going to attack us? Who has? Don't just think about that, all right? Versus Europe, for example, right? But if by indirect means the executive, the president, can involve us in war not declared by the legislature, if a treaty may be made which will incidentally produce war, or if the judiciary may determine a war to exist, although the legislature has refused to declare it. So like when the Supreme Court says, yeah, the War Powers Act is constitutional. No, it isn't. Don't give me that. I don't care what you say, Supreme Court. It's not. Congress has the sole power to declare war. Look what it says. If by indirect means the executive can involve us in a war not declared by the legislature, if the Supreme Court can say, yeah, that's cool, the Constitution is defective since it admits constructions which pawn our freedom. Ooh, Pendleton, don't hurt him. Which pawn our freedom and happiness upon the security of executive patriotism, which is inconsistent with Republican values. We're like Jefferson. We don't trust people in government. We chain them down. We bind them with the chains of the Constitution. Having an R after your name, a D after your name, I don't care, man. Don't care. No respecter of persons. You stay in your box or you're a tyrant. And if you're a tyrant, you deserve to be treated like a tyrant. Period. Preach, Uncle Algie. All right. In the Virginia, so this is Edmund Pendleton, more. In the Virginia Bill of Rights is expressed this inestimable sentiment. No free government or the blessing of liberty can be preserved to any people, but by a firm adherence to justice, moderation, temperance, frugality, and virtue, and by frequent recurrence to fundamental principles. There we go. Just like Madison said, you've got to remind yourself constantly, frequently, what principles led to the independence of the United States. Think about it. And now he says, a sentiment produced no doubt by the experience of this melancholy truth, that of men advanced to power, more are inclined to destroy liberty than defend it. There is, of course, a continual effort for its destruction, meaning the destruction of liberty by men in power, which ought to be met by corresponding efforts for its preservation. If men in power are constantly overstepping their bounds, we have to have a corresponding effort to force them back inside. These principles and propositions are most respectfully submitted to my fellow citizens with this observation, that it is only when great and good men are at the head of a nation that the people can expect to succeed in forming such barriers to counteract encroachments on their rights. And whenever a nation is so supine, and in other words, it's just laying down and letting stuff happen, as to suffer such an opportunity to be lost. What's the opportunity? To counteract against the encroachment on their rights. That when a nation is so supine as to suffer such an opportunity to be lost, they will soon feel that the danger was not over. Friends, the danger's not over. We have got to go back to fundamental principles. We have got to use our power to force the federal beast back inside his constitutional cage. We have got to make America states again. And as far as making America great again, as Pendleton said, America will be great again as soon as America is good again. There is no liberty without virtue. Guys, we have got to do this. The time is now. The danger is not over. We must push back. Listen to this video. Go click the links for the Report of 1800 and Edmund Pendleton's essay. Read them. Send them to your state representatives. Say, look, this is your obligation under Article 6 to enforce these limits, to keep this state sovereign. That is your obligation. When the wicked rule, the people mourn. Thanks, guys. Talk to you later.